So next we're going to start the horror, this family court quiz 4.
Who's doing that?
I'm still doing the beginning, and then where I quit, she's going to jump in. So first we're going to go through the issues on the first page, okay, in case you're not in my group text. The first one is fine. I'm just kidding. Proceedings under Article 10 may be, and the answer is 2 or 3, but not 1, in the county where the child resides when petition is filed, or 3, in the county in which the person having custody of the child resides or is domiciled when the petition is filed. Okay, so the answer is C there. Now, the next question, you have to make a correction. It says, in any case involving abuse, cross off the word abuse and write in 1022 removal. Yeah, it's pursuant to Article 1022. So now that generally is when there's an abuse. Or in any case where a child has been removed without court order, which is probably 1022, the family court shall hold a hearing the next day family court is in session after the filing of a petition to determine whether the child's interests require protection pending a final order of disposition. This is one of the few places in this stupid book where they actually got it right. They didn't have any nonsense about 24 hours, 72 hours, weekends, or any of that shit. They came out and said the next day family court's in session, period. That's where it should say everywhere. All right, next, number 3. Upon the application of a parent, cross off the word law guardian. We don't use that phrase anymore. It now is attorney for child. For an order returning the child, the court shall hold a hearing to determine whether the child should be returned, and it's both of them. It's upon good cause shown, or unless there was a hearing held pursuant to 1027 on the removal of the child at which the parent or PLR was present and had the opportunity to be represented. So if they had the hearing and the parent was there and they had no attorney, that doesn't count. Next, except for good cause shown, the hearing described in question 3 should be held within, wait, is that right? I put within 3 court days? It is right, okay. Within 3, again, they got it right here too. If there's going to be a hearing about whether the child should be returned, it's got to be held within 3 court days of the application and shall not be adjourned. So the next one, this is, you have to make another correction here. It says in an Article 10 case, cross off an Article 10 case, write in cases involving abuse. The petition and summons shall be served within 2 court days after issuance. If they cannot be served within that time, such fact shall be reported to the court with the reasons thereof within 3 court days, and the court thereafter shall issue a warrant. Okay, so B, 2 and 3. Number 6, issuance of a warrant described in question 5 shall always be required when the summons cannot be timely served. Not true, because if it's a non-domiciliary, they don't have to. The answer is B, is not required when process is sent without the state as provided in sub C of 1036. Next, number 7, which of any of the following may originate a proceeding? 1 is like Child Protective Agency, and 2 is a person on the court's direction. So D, 1 and 4. 8, if the court on its own motion wishes to order an ACD in an Article 10, the petitioner, respondent, and child's attorney must consent. And this is the one where they have that crazy rule about if they all agree to extend it basically indefinitely, they can do that. 9, an appeal may be taken as a matter of right from any order under the Family Court Act. False is any order of disposition, and then any other order if the appellate division gives them permission. 10, an appeal from the family court is brought to the appellate division. 2 copies of such notice of appeal with the clerk of the family court. 2 copies of such notice of appeal with the clerk of the family court.
Why? Because you're going to keep one and send one to the appeals court.
Yeah, this is about the abuse only.
Is that the right language, or should that say summons and petition?
Yeah, I hope we all figured out that that's what they meant, petition. Service shall be made within 10 days after issuance. Okay, this next question was horrible in my opinion. This question is either way, no matter what, you should have gotten none of the above because there's no time limit for the order of disposition. There's time rules about the permanency hearing and when the court has to complete the permanency hearing. The actual order of disposition does not expire on a specific date. Okay, and the other issue I had with this question, I'm probably the only one that had this issue, but 1051 is not talking about the actual order of disposition itself. It's talking about the notice that the court tells the parent or whatever. 1055 is the order section, and in 1055 it calls it the placement, but that's actually the same thing as placed in foster care. Okay? 1055, in the case of a substantial failure of a material condition in a surrender agreement and in the absence of the filing of a petition by the authorized agency as a result of that failure, the parent and or child's attorney may file such petition at any time up to 60 days after notification of the failure. Up to 60 days after notification of the failure. Question 15, you can totally cross off that question. So now question 16, you can cross off that question too, because combined the the Civil Rules 202 with the Family Court Act.
Just.
No, can you hand me my book? I want to just explain. 5.15. Proposed orders with proof of service on all parties must be submitted for signature unless otherwise directed within 30 days after the filing of the decision or whatever. Except in Child Protective and 10A, they shall be submitted immediately, but in no event no later than 14 days after the court's decision, unless otherwise directed. Again. Now, if they're a 1022, which is that like removal without the petition being filed, they have to be filed immediately, but in no event later than the next court date following the removal of the child. So we know that now, in that case, the next court date is the next day family court's in session. I'm in Rule 205.15.
In CPLR
Civil
decision,
Rules 202.
you got how many days?
60.
In family court in general, you have how many days?
30.
That's the key to remember. Don't get that mixed up. Go ahead.
Unless they're talking about Article 10, just remember immediately and in no event 14 days. Okay, so basically the reason I'm going over this is because the question was combining the civil rule with the family court rule. So just maybe read those rules together and try to remember what the times are on them. Okay, so I have a typo, 2 typos on number 17 to fix. The first one is that in number 2, it should say respondent with a T. And in number 3, notwithstanding should be one word. So with that, this says, in determining whether or not the family court has jurisdiction in a child protective proceeding, which if any of the following are true? Not true. 2, the child need not be currently in the care or custody of the respondent. That's true. 3, the family court has jurisdiction over the proceeding under Article 10, notwithstanding the fact that a criminal court also has or may be exercising jurisdiction over the facts alleged in the petition or complaint. And something that I thought was interesting in here was that the family court can actually grant someone testimonial immunity. Okay, so next proceeding is has to file their notice of appearance on or before their first appearance in court, or no later than 10 days after appointment or retainer, whichever is sooner.
Same as couldn't.
This is Barbara's favorite question, this next one. A term of court is a 4-week session of court, and there shall be 13 terms in a year. In a proceeding pursuant to Article 10, where the family court issues an order which will result in the return of a child that was previously remanded or placed by the family court in the custody of someone other than the respondent, such order shall be stayed until 5 p.m. the next business day, unless the stay is waived by all parties to the proceeding by written stipulation or upon the record in family court. Okay. 21, where the appellant in a family court matter under appeal is seeking relief to proceed as a poor person, pursuant to CPLR Article 11, the transcript of the proceeding appealed from shall be requested within 10 days of the order determining the motion. Now, this is different in civil. In civil, the court clerk has to notify the court stenographer within 2 days, and then it has to be done within 20 days. So this one is saying that the person who's appeal, the appellant, has to request it within 10 days. 22, each support magistrate shall file with the chief administrator. Now, it is beyond my imagination why I would ever have to know this, okay?
Been on multiple exams, though.
They don't, okay, for the record, who works with support magistrates? Is it court clerk? Is it associates and principal court clerks? Ever? No. Why I would have to know what they have to do, I don't know. But anyway, the answer is quarterly. Report indicating the matters that have been pending undecided for a period of 30 days after final submission, which, if any, are required in order for the family court in any proceeding to make an order of filiation declaring the paternity of the child. Okay, so this is a strange pop-up question, but it's good to know. 1, there is an allegation or statement in the petition that a person is the father of a child who is a party to the proceeding or is also a subject to the proceeding. And 2, it appears the child was born out of wedlock. And 3, both parents are before the court, and the father waives the filing of the petition and the right to a hearing, yes. 5, the court is satisfied as to the paternity of the child from the testimony of the parents, basically. So it's all of them, A. And then for the purpose of this, the term petition includes a complaint in a civil action, a writ of habeas corpus, an accusatory instrument under the CPL, a petition for supplemental relief, or an amendment in writing of numbers 1, 2, 3, and 4. So it's all of those things. So, yeah. Okay, number 25. What's the matter?
No, I said maybe that's how they sneak that unverified. Some complaints don't have to be verified, but they consider petition to get to work.
Yeah, but that still wouldn't be. Oh, okay, yeah, that's kind of a reach, but okay. Yeah, keep trying. There's got to be one out there. They wouldn't have to tell us when it was verified, right? Number 25. D. Okay, so the next one is, it's everything they can request the subpoena from a public or private agency having records relating to abuse or neglect, except for a probation service. So the really interesting one is number 6, a party to the proceeding. Because usually who can't issue a subpoena? Okay, on a hospital, okay? But it's the court, corporate counsel, DA, AFC, party to the proceeding, or a county attorney. All of them can do it here, except probation service. 26, in Article 10, the family court has exclusive original jurisdiction over those proceedings. 27, so in a fact-finding hearing, which is a hearing to determine whether the child is an abused or neglected child, which of the following are true? 1, any determination that the child is an abused or neglected child must be based upon preponderance of the evidence. True. 2, whenever a determination of severe or repeated abuse is based upon clear and convincing evidence, the fact-finding order shall state that such determination is based on such evidence. And 3, except as otherwise provided by this article, only competent, material, and relevant evidence may be admitted. So it's all the above and no hearsay. The dispositional hearing and during all other stages of the proceeding under this article, which is Article 10, except for a fact-finding hearing, only material and relevant evidence may be admitted. So everywhere else you can have hearsay, except for fact-finding. Okay, 29, and you should, Mary, start coming up, because I think this is about where I quit on this quiz. Okay. The family court may enter an order directing the temporary removal of a child from the place they're residing before the filing of the petition, when which, if any, of the following are true. And this is why I think they used to just call this like a case involving abuse, and now it's the 1022 pre-petition removal. And you're gonna need all of these things. 1, the parent or PLR is absent, or though present, was asked and refused to consent to temporary removal and was informed of an intent to apply for an order under this section and of the information required by 1023, whatever that is. And 2, the child appears to so suffer from abuse or neglect of the parent that removal, immediate removal, is necessary to avoid imminent danger to the child's life or health, and there is not enough time to file a petition and hold the preliminary hearing under 1027. You need all of those things. And I think 30 is like a repeated rules question.
Yeah.
Here you go. So, is there anyone who cannot get here at 5:20 who's taking 3 next week?
Yeah.
Great. So that means,
Social services sections that are only for the principals.
yeah.
Want to do quiz 1, domestic relations?
Yeah.
You want to go?
Oh, hell no. I didn't even know any of these answers. You have to go.
Your father did this last week, right?
Yeah, I didn't read it after that, so I didn't
Okay.
know the answers. Okay, anyway, secured bail bond means a bail bond secured by personal property worth 100% or more of the total amount of the undertaking, not exempt from execution. B, real property twice the value of the total amount of the undertaking, and that's above the liens and encumbrances. C, cash. You can always post cash. Wrong, because it's not a bail bond. It's cash bail. It's wrong, but I'm telling you, you can always post cash. Okay, because C is wrong because it's not a bail bond. No, it's just cash. But yeah, you can always pay cash. But the answer is A and B.
Some people would argue that C is just a subset of A.
Who can move for a mistrial? And it's all 3 of them in conformity with the law. So the court officers all walk out one day and say, we're done, we're leaving. Then the court basically has got to declare mistrial.
I understand that this happened.
You have to bring up something depressing. I'm trying to make it lighten the mood here a little. We're all depressed anyway.
Nobody's depressed.
We're
You
all
guys are
depressed
well
and
prepared
miserable
for
because
this
your
test.
family court quiz
They're gonna
4.
come-
33, if it rains upon an accusatory instrument other than a felony complaint and before the imposition of sentence, the court becomes of the opinion that the defendant may be an incapacitated person. The court must issue an order of examination.
Stop.
Or after a felony complaint and before the person is held for the action of the grand jury, it must issue an order of examination.
Please don't forget that. Must order an order of examination, not the other things.
What's the difference? Tell me where it goes, examination order, order of examination.
Okay, I'm going to tell you. So in this article 730, we're not even getting to trial. Okay, guy is too or girl is too crazy to even go to trial, and they don't know why. They don't even think they're crazy. They think that they're normal. Okay, so that's usually how it works. They don't think that